I'm going to be talking today about how corporate spending was converted into protected First Amendment speech in 1978, much earlier than people think. All right, many people today know that at some level, in 2010, the Supreme Court opened the door via the First Amendment to permit greater influence of corporate money on democratic processes than ever before. Since that time, there has been and continues to be tremendous discussion and debate over that ruling, Citizens United versus Federal Election Commission. That's because the 5 justices in the majority essentially said that the First Amendment protects corporate managers spending their stockholders' money for political media purposes is no different than a human being standing up and expressing their political views. The fact that the justices in the majority found no difference between those two actions resulted in the ruling more sweepingly than ever before, protecting corporate political media spending from regulation long aimed at preventing corruption of political campaigns or the appearance of such corruptions. Now, many people feel this ruling just came out of the blue, and they wonder how the Supreme Court could have arrived at such a decision. In fact, the ruling did not come out of nowhere, yet it did depend overwhelmingly on a single ruling from about a quarter century before, which much more justifiably can be characterized, if a ruling can be, as coming out of nowhere. And it was in First Amendment, First National Bank of Boston versus Bellotti in the spring of 1978, that another 5-justice majority at the court actually for the first time brought corporate political media spending within the protections of the First Amendment. Protections that until that time had been extended formally only to natural human beings. Now, without the holding that it institutionalized in First Amendment case law, corporate managers would be able only to spend their own money rather than that of their stockholders for political media purposes. To give you a vivid example of how dependent Citizens United was and is on the Bellotti case, the majority opinion in Citizens United cited Bellotti 24 times. 24 times. That's remarkable. And it's quite arguable that without Bellotti, there could be no Citizens United. And without Citizens United, the political landscape of today, with corporate spending unleashed in virtually unlimited amounts, would be very different. So let's look back at this remarkable moment in the history of interpreting constitutional law to a case that began this dramatic revision in the meaning of freedom of speech. That case, Bellotti, arguably would not have happened without the efforts in late 1977, early 1978 of Justice Lewis F. Powell, Jr., who had been a very successful and influential corporate attorney before joining the court a few years before, to put together that 5-4 majority for it. In fact, if you spend time in the late Justice Powell's private papers in the archives at Washington and Lee University School of Law in Virginia, you'll see that the ruling was so contentious among the justices that it almost never happened. So intense was the opposition among the other justices then on the court. Justice Byron White summarized what a number of justices insisted was established law at the time. Quote, "In short, corporate management may not use corporate money to promote what does not further corporate affairs, but what, in the last analysis, are purely personal views of the management, individually or as a group." A few years after the ruling, after the Bellotti ruling, one legal scholar wrote, "What is perhaps most remarkable about the court's opinion in Bellotti is the virtual absence of the corporation from it." It may seem preposterous to make such a statement about a case that more than any other opened the door to First Amendment protection for corporate spending. And yet when you examine Justice Powell's papers, you see that's exactly how that came to be. From the very beginning of his discussions with the clerk who assisted him in writing the majority opinion in Bellotti, they focused not on the question of corporate First Amendment rights. They focused more on reframing the matter in terms of abstract, quote, expression of views. In a literal sense, of course, the artificial being that is a corporation cannot express views or anything else. Its managers, employees, stockholders, and other parties interested in a corporation's operations can express their views, and of course their right to do so was constitutionally protected long before Bellotti ever got to the Supreme Court. So what was at issue in that case, and essentially in all the similar cases since then, was whether the First Amendment can be used to block regulation of corporate managers' spending directly from their corporate treasuries, which in principle belong to the stockholders, on media communications aimed at influencing political outcomes. Now, Justice Powell and his clerk, as I said, who assisted him on Bellotti, early on they focused on disregarding the source of the speech, corporations, and focus instead only on speech in abstract. As his clerk wrote to Justice Powell early on, otherwise they would probably not be able to form a majority at the court. There was simply too much opposition among the other justices, including some of those who ended up joining the majority. They felt it would undermine historic, extensive efforts to prevent, in both federal and state law, to prevent corruption of democratic processes by corporate spending. And again, those laws go back to early in the 20th century, shortly after the rise of the corporation as the dominant economic form of business that we know today. And laws aimed at expanding protection of democratic processes from corporate spending had been expanded in the 1970s and the 1990s and upheld. Now, there is a 1976 case, Buckley versus Vallejo, that established that because mass media have grown so expensive in our time, money is equivalent of speech, or can be, in terms of political expenditures. And it's a complex ruling, but the court essentially in Buckley versus Vallejo found that giving money directly to a candidate clearly represents a form of quid pro quo corruption that can be regulated, but that individuals spending money to advocate political issues could not be regulated. That ruling, however, very clearly did not address corporate spending on political advocacy or in campaigns. And in their discussions of the Bellotti case, when it arrived just 2 years later, so you have essentially the same group of justices on Bellotti as on Buckley Vallejo, a majority indicated they could not support expanding First Amendment rights specifically to corporate spending. Again, because they felt it would undermine these long-established corporate corrupt practices laws. However, the corporate plaintiffs in Bellotti argued that the government could not restrict corporate spending aimed at influencing the outcome of a referendum. In other words, an election focused not on candidates but on issues, and that using corporate spending for that purpose was just another form of speech. That was the argument. When Justice Powell began drafting his opinion in the case, he did not yet have majority support for that would embrace that assertion. In his discussions with his clerk, they agreed it was crucial that so far both sides in the case, from the lower courts all the way to the Supreme Court, had phrased the central question as, do corporations have First Amendment rights? They agreed. The court had never held that. And at one point, crucially, the clerk wrote in a memo to Justice Powell, quote, "If, on the other hand, one conceives of the problem in terms of what is prohibited rather than who is guaranteed a certain right, then the fact that appellants or corporations takes on a different significance." And that early memorandum by the clerk also emphasized that the theme should be the speech at issue here is at the core of the First Amendment and therefore presumptively protected. The opinion need not address whether corporations have First Amendment rights similar to those of individuals. Justice Powell agreed, and he very specifically stated that they were not reaching that question in Bellotti. So again, focusing on protecting the speech in the abstract, regardless where it came from or who paid for it. Nevertheless, forming a majority for this opinion proved a slow process. Only Justice Potter Stewart joined immediately. Justices Harry Blackmun and John Paul Stevens and Chief Justice Warren Burger joined only after language they insisted upon to narrow the holding was added. And though Justice Powell lobbied rather aggressively among the remaining 4 justices to expand his majority further, his efforts were strongly rebuffed, to say the least. I'll come back to that. The Supreme Court's ruling in Bellotti held that corporate spending on communications seeking to influence the outcome of referenda does not lose its First Amendment protections simply because its source is a corporation. Both Justice White, Byron White, and Justice William Rehnquist, he was not Chief Justice at that point, wrote strongly dissenting opinions, proclaiming the majority decision was completely at odds with settled law. Despite having joined the court on the same day in 1972 as Justice Powell, as part of Richard Nixon's efforts to move the court back to the right from the Warren era, President Nixon was able to appoint 4 justices to the court, and Justice Rehnquist and Justice Powell were 2 of them. Justice Rehnquist made clear he brought a very different understanding of the corporate being's standing in law, including First Amendment law. He wrote, "I would think that any particular form of organization upon which the state confers special privileges or immunities different from those of natural persons would be subject to like regulation, whether the organization is a labor union, a partnership, a trade association, or a corporation." And again, that was deeply established view in law at the time, and still is among many legal scholars and justices. Justice Rehnquist and Justice White continued to press their views, their arguments in subsequent cases on corporate political media spending, particularly in the 1980s, that further narrowed the doctrine after Bellotti. And that process produced its most forceful counterbalance in Austin versus Michigan State Chamber of Commerce in 1990, a 6-3 ruling that declared it constitutional to bar corporate spending in connection with candidate elections. Justice Powell had left the court by then, but all the remaining justices from the Bellotti ruling voted in the majority, in the Austin majority, indicating their view that it was not incompatible with Bellotti to regulate that type of corporate spending. Later campaign finance legislation that focused on corporate spending was also upheld in as recently as 2002 in McConnell versus Federal Election Commission. And that was the most substantial case on corporate media spending since Austin. The majority opinion again emphasized Congress's century-long efforts to restrain the influence of corporate spending on democratic processes. However, by 2010, the Supreme Court had been reconfigured considerably, and a new 5-justice majority in Citizens United overruled those central holdings in the 2 cases I just cited, Austin and McConnell. As I noted earlier, the majority opinion in Citizens United cited Bellotti 24 times and characterized it as a holding much more sweeping and deeply grounded in established precedent than either the papers of Justice Powell or the intervening cases between Bellotti and Citizens United would indicate. Indeed, Citizens United virtually ignores most of the cases on corporate media spending that came between it and Bellotti, focusing almost totally on Bellotti. And that may be understandable when one considers that without Bellotti, indeed without a very broad, generous reading of Bellotti, it's very hard to see how Citizens United could have ever been possible. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.